1 and 2 that the Constitutional Convention was saying, okay, legislature, under these subsections, it's entirely up to you. But in subsection 3, yeah, we're going to give the legislature the first pass at it, but if you screw it up and you end up with unreasonable depletion, then the courts can come in and backfill if you haven't done your duty there. So that's my sort of rhetorical proposition. I'll let the panel address that.
Okay, and would you like to go first, Joe?
Sure. Well, I'm not a lawyer. I only play one at the legislature. So, I mean, I guess all I can do is quote the best legal minds that I know, and that would be former UM constitutional law professor Rob Nadelson. And he would argue that very adamantly that with the MEIC decision, that the court clearly declared that the environmental right is a self-executing right that can be enforced by the courts outside any legislative parameters whatsoever. Again, going so far as to say anything that implicates the environment. It didn't even say negatively or positively. It said anything that implicates the environment, that you must show a compelling state interest, not a compelling personal interest, a compelling state interest in order to justify that action. And I would argue that that's a test that is simply not passable if the courts continue to choose to exercise it. Now, they'll selectively exercise it, but what you have done has turned that power over to judges as opposed to what I would argue is a political question, and that historical jurisprudence would have said these political questions that involve, where do you draw the line, are best left to legislative bodies. And that gets back to Mr. Johnstone's question about, the conflict. Well, what do you do with the Otter Creek tracts versus this right to a clean and healthful environment? I mean, you've got constitutional provisions that on one hand say they're supposed to maximize the income generated from these state lands to help schools, and yet on the other hand, you've got this environmental right that basically the courts have interpreted to say, if you do anything that even implicates the environment, it's in the hands of a judge. And historical jurisprudence said that those types of where do you draw the line questions are better off left to legislative bodies than left to judges. So, and then just to finalize Mr. Johnstone's question, he says, so, if you've got this problem with it, it only takes a majority to amend it. Okay, I don't know if you're aware, but in order to amend the Montana Constitution, you can either do it with a constitutional referendum. I mean, I know you're aware of this. You can do it with a constitutional referendum or a constitutional initiative. In either case, it ultimately goes to a majority vote of the people. But I can tell you that the last 6, now the last 7, conservative referendums or initiatives have all been thrown out by the Montana courts. I would argue that there is no referendum or initiative process in the state of Montana for conservatives. There is only an initiative and referendum process in Montana for liberal ideas. So I don't think it can be done. That's as a result of the Marshall decision, by the way, which I believe was in 1999.
I'll
pass on that in the interest of time.
Okay, I'll come back to the judge.
I would like to make an observation, and again I have to remind the audience of my disclaimer, particularly since we have the pleasure and privilege of having with us a sitting justice on the Montana Supreme Court, Pat Cotter, and we have the retired Chief Justice of the Montana Supreme Court, Carla Gray, who was on the Supreme Court at the time the MEIC decision was made. So my comments are as a delegate to the Constitutional Convention and reading the MEIC case. Now the court clearly limited their decision to one provision of the law passed by the legislature that exempted from review groundwater discharges from wells. Well, of course, involved are the 7-Up Pete mine near Lincoln, and the cyanide processing and arsenic involved in gold processing results in some kinds of pollution that are pretty severe, they're pretty toxic. But the legislature says, not subject to review are discharges into the groundwater. And the Supreme Court says, well, wait a minute, you went too far. And I certainly concur with the Supreme Court, made a right-headed decision with respect to that one very narrow subdivision, subsection of the bill that had been passed by the legislature in trying to enact a provision which was in complying with the dictates of the 1972 Constitution. But they were enacting, the legislature was making an effort to have a non-degradation policy enacted by the legislature. But I can guarantee you that that provision of no review of groundwater discharges wasn't written by the Sierra Club or the Friends of the Swan. I can guarantee you that the specter of an attorney for the gold mining companies was lurking in the halls of the legislature when that non-reviewable policy got squirted into that statute, and it contravened the Constitution, and the Supreme Court was absolutely correct to find that it was unconstitutional.
Thank you, panelists. Well, we've been given a little more time. At first, I thought an hour and 15 minutes was a lot of time, but it turns out it's not. So Ken has given us a little more time. I have a question back here, and then I had another hand over here, and then one in the back, and I think that'll be everything. Then I'll have a few concluding remarks. So, sir?
I have to thank Joe Balyeat for reminding everybody that I'm a bow hunter and so old that I confused arrows with quivering. Thank you very much, Joe. I am disappointed, I must say, to learn that the constitutional delegates trusted the legislature. The founders of the United States, the framers of the Constitution, clearly did not, to the extent that they specified a series of amendments to limit legislative power. One of them, the Fourth Amendment, with its protection against unreasonable searches and seizures, clearly left to the courts the decision of what was unreasonable. But Joe, you drew a bright red line between negative and positive rights and said the framers avoided giving any entitlement rights. The Sixth and Seventh Amendments, which include entitlement to a public trial by jury, are entitlement rights. Wouldn't you agree?
I did, and if you go back and look at the, I think I probably would to a certain extent, but I think that there's a compelling interest in providing them. But in my written comments, and by the way, I've got copies of my comments down here if anyone would like to take them, the wording I actually used, and again, when you're making comments verbally, you sometimes stray from your written comments. But I thought of that particular question, believe it or not, Brian, when I was putting together in my written comments. And the language that I used, or was supposed to use, was that the framers carefully attempted to avoid the inclusion of any positive rights, rather than to say that they avoided all positive rights. They carefully attempted to avoid that. And I will acknowledge that it is not an exact science.
Okay. So I have the gentleman here.
Assuming there was no environmental provision in the Montana Constitution, we would still have the right to liberty that's in all constitutions, which is generally considered the right to be let alone, the right to be free, it could be argued, from poisonous air, the right, a rancher might argue that you can't make discharge substances in the river that cause my cows to be sick. So if we didn't have a provision in the Montana Constitution giving some guidance to the court, wouldn't we have them in effect writing the environmental law without that guidance?
Jerry, we just simply thought it was too important to leave out. That was just the mood of the state, the delegates, and I think of the country at that time, that the environment was just too important to ignore. And so what we attempted to do was provide some very fundamental but sound basis and positive basis for constitutional provisions that ought not to be contravened.
A follow-up?
I didn't mean it shouldn't be left out. I just was making a comparison to, or not comparison, but the kind of distinguish between whether the legislature would be writing the law for the courts, more so.
But my response to that, sir, would be that if the Montana court had not abandoned, again, the historical jurisprudence puts a lot of self-restraint on courts. You know, last night they talked about how the Constitution set up checks and balances, that there would be a balance of power. Well, if you really think about it, there's a check and balance on the legislative branch because they can either be vetoed by the governor or thrown out by the court. There's a check and balance on the executive branch because they can be, their veto can be overridden by the legislature or their actions can be thrown out by the court. But there really is no check or balance on the court. Not even the combined power of the legislative branch and executive branch together can override the court. And so historically, under rules of historical jurisprudence, courts operated in a system of self-restraint. And I don't have time to go into it here, but I actually gave a speech before one of the Law and Justice Committee in the Senate, where I talked about how the Montana courts, in my view, have abandoned self-restraint in 6 different areas of historical jurisprudence. Okay? And the answer, to get back to the answer to your question, I would say if the Montana court was bound with self-restraint by these 6 different issues of historical jurisprudence, they would have limited themselves and not ventured into the type of activity you talk about. Unfortunately, I don't believe that, I think they've abandoned those 6 types of self-restraint. And so yes, we could have a problem.
Much more could be said. I have 2 questions still out in the audience and just a couple of concluding remarks, and I'm happy to see people are not drifting away. I appreciate it. So, sir, in the back. No, you. Yeah. Didn't you have your hand up?
It's been 40 years since I studied all 50 state constitutions, and my view was not to, my task was to study legislatures, not the Bill of Rights. But in looking at all those 50 state constitutions, the preeminent reason for the constitutions was the Bill of Rights, or the Declaration of Rights. And the federal government has delegated authority, the states have plenary authority. And almost all of the constitutions, especially from the New England and middle states, were communitarian. And they stressed, as our Constitution does, a compact between the whole people to the individual and the individual to the whole. And so all of our Bill of Rights and Declaration of Rights in those 50 constitutions were far more enumerated than in the federal. And that was the purpose, is that they were saying, we are giving almost unlimited power to our frame of government. We framed one very well, but we're making caveats that you can't go beyond these. So I think it's quite appropriate what they did, and I applaud it.
And thank you for giving us the benefit of that research. Yes, ma'am.
I think too often we want either or. We either want the Constitution to do it or the legislature to do it, and then we let it fall to the judges. But, you know, as far as statutory interpretation, you've got 3 levels right there where the Constitution frames the conceptual framework and what they intended. You've got first the plain language of the statute, then you've got the intent behind what the framers did, and then you've got the history behind it. And then I think, so you put the framework, and then you have the legislature come in with all the conditions that maybe give the test, that give then guidance to the judges. And